A federal judge ruled the Trump administration cannot withhold millions of dollars in emergency preparation funds from states that haven't proven their population counts. In October, the Federal Emergency Management Agency ordered states to provide updated population numbers and to account for deportations before they can get any FEMA grant money. 11 states sued, and the judge ruled that FEMA could not randomly shorten the window in which states could use emergency grants or money awarded.
Hey guys, welcome. Adam is here. So what just happened now? A federal judge just put words in a binding court order that legal scholars are calling the most explosive judicial statement since the Nixon era. Not a footnote, not a closed chamber's whisper. An emergency injunction signed and delivered into permanent constitutional history, stating that the president appears to be treating emergency declarations as a license to throw ordinary constitutional limits out the window.
And President Donald Trump has approved an emergency declaration for Texas as a powerful winter storm impacts much of the country.
The declaration will help state and local officials provide emergency services and resources during the storm. Texas is among several states included in that action. The declarations also include Indiana, along with Tennessee, Georgia, North Carolina, Maryland, among other states. President Trump posted on social media that federal, state, and local teams are working together to keep people safe.
An Article 3 judge with lifetime tenure, trained to measure every syllable and avoid inflammatory language, chose those exact words anyway, because the evidence left no honest alternative. Legal scholars are already comparing it to the moment courts finally stood up to executive overreach. A federal judge just accused the president of flirting with martial law, in writing, on the record, forever.
Barbara, I'll start with you and these comments, these rare comments, I should say, public rare comments from Judge Reggie Walton. First, just give us some context for what it means for a sitting federal judge to speak out like this in this manner. And what do you think of what he had to say about what him, his family, and other judges are experiencing, all because of the cases they are taking?
Well, judges traditionally think of their comments as coming only through their orders. They are typically pretty loath to make public comments, particularly about any particular case, because they don't want to suggest anything other than impartiality. And so I think it is quite extraordinary for the judge to be speaking out here.
Let me say that again so it lands exactly where it needs to land. A federal judge in an official court order has written that the president's governing logic looks structurally identical to the logic of martial rule, that the president is using emergency statutes not as tools for responding to genuine crises, but as deliberate mechanisms for bypassing the constitutional framework that has governed this nation for nearly 250 years.
Attorney General Brian Frost and I are here today to announce that earlier this morning, the state of Maryland and the District of Columbia filed a lawsuit in federal court against the President of the United States. The suit alleges that President Trump is flagrantly violating the Constitution, which explicitly bars presidents from receiving gifts or inducements from foreign or domestic government entities. Never in the history of this country have we had a president with these kinds of extensive business entanglements, or a president who refused to adequately distance themselves from their holdings. As I look out the window and see the tower of the Trump International Hotel, we know exactly what's going on every single day.
That the pattern of conduct documented by the challengers and found credible by the court demonstrates an operating theory of presidential authority that has no foundation in the Constitution and no place in American democracy. This is not a Democratic Party press release. This is not an opposition research document leaked to a friendly media outlet. This is a federal court, the branch of government specifically designed to check the other two branches when they exceed their constitutional limits.
Welcome to the NewsHour. Over the last few days, President Trump has repeatedly questioned the right to due process, a fundamental right guaranteed by the Constitution that protects people against arbitrary government actions.
The president's attacks come as the courts increasingly warn that the president is exceeding the scope of his authority. Our White House correspondent Laura Barone Lopez has this report.
At an event today announcing Washington, D.C. as the host city for the 2027 NFL Draft, President Trump again doubted the need for due process under the Constitution.
It's a very difficult thing with the courts because the courts have all of a sudden, out of nowhere, they said, maybe you have to have trials. We're going to have 5 million trials. Doesn't work. You wouldn't have a country left.
The branch whose entire institutional identity is built on careful analysis, restrained language, and the deliberate avoidance of political drama. That branch just looked at this president's conduct and said in writing, for the historical record, that it looks more like an attempt to edge toward martial-style rule than like legitimate constitutional governance. Now, before we go any further, let me be completely precise about what this ruling actually says and what it actually does. Because the martial law framing is serious. It deserves careful treatment. And I am not here to sensationalize beyond what the court actually found. The judge did not declare that martial law has been formally proclaimed. The judge did not find that troops are about to roll into American cities tomorrow morning. What the judge found, based on the specific legal arguments and the documented pattern of conduct the challengers laid out, is that the president's approach to governing across multiple domains displays a logic that is structurally indistinguishable from the logic of martial rule. That treating emergency declarations as automatic triggers for suspended constitutional limits is not a creative interpretation of existing law. It is the rejection of law itself. The distinction matters because the actual finding is serious enough on its own terms. A federal court concluding that the president is operating under a theory that emergency authority functions as a license to bypass Congress and concentrate power in the executive branch is by itself one of the most significant judicial statements about executive overreach in modern American history. We do not need to inflate it. We need to understand it. And understanding it requires walking through the three-part pattern the challengers presented, and the judge found sufficiently compelling to issue an emergency injunction that temporarily blocks specific exercises of the president's claimed emergency authority while the full legal challenge proceeds through the appellate system. Here's the first element of that pattern. The Iran military operation launched without congressional authorization, sustained well beyond every statutory time limit Congress has ever written to constrain presidential war powers, justified through emergency declarations rather than legislative approval, accompanied by explicit public statements from the president claiming the right to continue that operation until he alone decides to stop. That is not a commander-in-chief responding to an imminent threat within constitutional boundaries. That is a president asserting that his unilateral judgment about national security supersedes the specific constitutional requirement that Congress authorize sustained military operations. The Constitution gives Congress the power to declare war. The War Powers Act gives Congress the ability to limit unauthorized military engagements to 60 days. This administration passed both limits and kept going. And when challenged, the defense was always the same: emergency, crisis. Presidential authority expands during emergencies. The judge looked at that defense and said no. Even in wartime, even in genuine crisis, the Constitution does not permit what you are doing. Here is the second element: the domestic deployment statements. The ongoing public references to using the Insurrection Act against protesters in American cities. The planning documents that have been made public showing Day 1 executive order templates for domestic military law enforcement. The drafted proclamation from 2020 that was only stopped at the last moment because military leadership pushed back and refused to go along. These are not speculative concerns about what might someday happen. These are documented statements from the president's own mouth. These are documented planning materials from inside the administration. These are real actions that were only prevented by the intervention of people inside the system who recognized how far outside constitutional limits the president was trying to go. The challengers presented this pattern to the court not as a list of separate incidents, but as evidence of an underlying theory. a theory that the president can deploy military force against domestic political opposition whenever he decides the situation qualifies as an emergency. And the judge looked at that evidence and found that the theory itself is constitutionally indefensible regardless of which specific crisis the president cites as justification. Here is the third element: the emergency tariff declarations, using the International Emergency Economic Powers Act in ways that even the Supreme Court has ruled exceeded the president's statutory authority. Claiming emergency economic powers to restructure permanent trade policy without congressional approval. Doing things that 50 years of prior presidents across both political parties never attempted because everyone understood those things required legislative action. The challengers argued to the court that these three patterns are not three separate policy disagreements. They are three expressions of the same underlying constitutional theory. And that theory is that declaring an emergency creates a different legal universe, a universe where the normal distribution of authority between the branches is suspended, a universe where Congress's specific constitutional powers can be bypassed because the president has decided the situation is too urgent for the legislative process to work the way the founders designed it to work. The judge agreed with that argument, and that agreement is why the ruling is so much broader and more consequential than any single incident court challenge could ever produce. Because the ruling does not just block these specific actions, it identifies and condemns the underlying theory that produced them. And it says clearly, directly, and without equivocation that this theory has no place in American constitutional law. That means every future emergency declaration resting on the same theory faces a court that has already found the theory constitutionally indefensible, whether the emergency is military, economic, or domestic, whether the crisis is real or manufactured, whether the statute being invoked is the Insurrection Act, the War Powers Act, or the International Emergency Economic Powers Act. The underlying logic is the same. And the court has already ruled that logic unconstitutional. Now let me talk about the wartime exception argument, because this has been the administration's primary legal defense for the most aggressive uses of claimed emergency authority, and the judge addressed it head-on in the most direct possible terms. The administration's defenders have been arguing consistently that in wartime or during genuine national security crisis, the president's constitutional authority expands dramatically, enough to justify the Iran war without congressional authorization, enough to justify domestic deployment planning, enough to justify emergency economic restructuring that bypasses the legislature entirely. The judge rejected that argument completely, without qualification, without the careful hedging language that courts normally use when they are reluctant to directly contradict executive branch claims. The ruling states plainly that even in wartime or genuine crisis, the Constitution does not permit a president to rule unilaterally, does not permit using the military as a domestic political instrument, does not permit emergency declarations to function as a constitutional off-switch that transfers legislative authority to the executive branch. That finding is the legal foundation of everything else the order does. And it is the judicial statement that is going to reverberate through every future legal challenge to this administration's emergency authority claims. The wartime escape route is closed in this circuit by this ruling. The administration cannot simply declare a national security emergency and argue that normal constitutional limits no longer apply. The court has said that argument is legally insufficient at its foundation, that the Constitution does not suspend itself during crisis, that emergency powers exist within the constitutional framework rather than above it. That is not a narrow technical ruling on a procedural question. That is a direct constitutional statement on the merits, and it applies to the Iran war argument. It applies to the domestic deployment argument. It applies to the emergency tariff argument. And it applies to every future argument that rests on the same theory of suspended constitutional limits. Now let me walk you through what the emergency injunction actually does in practice, because the immediate operational effects are separate from and additional to the significance of the language the judge used to justify it. The injunction temporarily blocks specific exercises of the president's claimed emergency authority, while the legal challenges proceed through the appellate process. Broad domestic deployment of military forces under emergency claims. Sweeping emergency economic measures that bypass congressional approval. These specific actions are now blocked unless and until a higher court says otherwise. That blocking order creates an immediate binary choice for the administration. There is no comfortable middle ground. There is no clever third option that avoids the choice entirely. Comply with the injunction. Accept that the court has the authority to block these specific exercises of emergency power. Proceed to the appellate process to challenge the ruling through normal legal channels. That option is legally responsible. It is what administrations normally do when they lose in court. But it is politically costly because it means publicly acknowledging that a court has successfully constrained the emergency authority the administration has been asserting without limit. It means admitting that the constitutional system of checks and balances still functions, that the president is not above the law, that courts can say no, and the executive branch must listen. Defy the injunction. Continue the blocked actions in the face of a direct federal court order, and face contempt proceedings that would create a constitutional confrontation more dramatically damaging than any adverse ruling the administration has ever received. Defying a federal injunction is not a political statement. It is not a campaign talking point. It is not something you can spin your way out of with a social media post or a rally speech. Defying a federal injunction is a legal act with specific and serious consequences. Contempt findings, escalating sanctions, potential incarceration orders for officials who refuse to comply. The administration's legal team understands this binary clearly. It is why this specific ruling is generating more internal alarm than any previous court loss, including the Supreme Court tariff ruling. Because the tariff ruling was a constitutional loss on a policy question. It hurt. It was embarrassing. But it did not create an immediate operational constraint with enforcement mechanisms attached. This injunction does. Now let me talk about why the challengers structured their argument around a pattern rather than individual incidents. Because this is legally sophisticated and it makes the ruling significantly broader and more durable than most single-incident court challenges produce. Instead of attacking one specific emergency declaration in isolation, the challengers presented three separate categories of conduct as manifestations of one underlying unconstitutional theory. And they argued that the court should evaluate the pattern because the pattern is what reveals the operating theory, and the operating theory is what needs to be constitutionally addressed. Think about the difference this makes. If a court rules only on a single incident, the administration can change the specific mechanism and make the same argument under a different label, use a different emergency statute, cite a different crisis, claim a different justification. The underlying theory remains intact. The court has only addressed one symptom, not the disease. But if a court identifies and rules on the underlying theory itself, that declaring emergencies transfers legislative authority to the executive, then future declarations resting on the same theory are subject to the same challenge regardless of what specific statute is invoked or what specific crisis is cited as justification. The ruling does not just block these specific actions. It undermines the legal foundation for the entire emergency governance model that the second term has been built around. Every future emergency declaration faces a court that has already found the underlying theory constitutionally indefensible. That is a much broader and much more lasting consequence than any ruling on a single incident could produce. Now let me address something that does not get talked about enough when people analyze rulings like this: the judicial courage dimension. The decision to use martial law logic language in an official order directed at a sitting president is not made easily and should not be taken for granted. Federal judges are appointed for life specifically to insulate them from political pressure. But that insulation does not make using this specific language about this specific president at this specific moment consequence-free. The president has already publicly called judges criminals. He has demanded crime bills to punish rogue courts. His supporters have made statements about specific judges that created documented safety concerns requiring federal marshal protection. The Justice Department, under his political direction, has been accused of targeting critics of the administration. A judge who issues an order explicitly characterizing the president's governing logic as Marshall-style overreach is doing so with full understanding of what the political response from the administration is going to look like, and is doing it anyway, because the evidence presented and the constitutional principles at stake require the most accurate possible description of what the court is finding. That institutional courage matters. A court willing to use the accurate language rather than the diplomatic language that minimizes political conflict and personal risk is itself a constitutional event. It signals that the judiciary has concluded the threat to constitutional governance is serious enough to require the most explicit possible judicial statement. That the careful, restrained language federal courts normally use to describe executive overreach is no longer adequate to the gravity of what this specific pattern of conduct represents. That silence or hedging or diplomatic understatement would itself be a failure of judicial duty. The judge chose accuracy over comfort, and that choice is now part of the permanent constitutional record of this era. Now let me walk you through the full political consequence dimension, because martial law language in a federal court order does not stay contained within the legal domain. It travels. And the travel is immediate and significant, into the impeachment arguments where members filing articles can now cite a federal court finding that the president appears to be operating under a theory that treats emergency authority as a license to suspend constitutional limits. That is not a political talking point. That is a judicial finding from a federal officer with lifetime tenure whose professional function is to evaluate exactly this kind of constitutional question. It makes the impeachment argument more credible, more specifically grounded in official findings, and harder to dismiss as partisan overreach. Into the 25th Amendment discussions where advocates can now point to a federal judge's characterization of the governing logic as martial style rather than constitutional as evidence that the fitness concerns they are raising have judicial validation. The 25th Amendment was designed for exactly this kind of situation. A president whose governing approach raises fundamental questions about constitutional fidelity. And now there is a federal court order that can be cited in those discussions as an official judicial finding, not a partisan document. Into the war powers resolution fight where senators pushing for a floor vote can cite a federal court ruling that even in genuine wartime, the Constitution does not permit unilateral military rule or domestic military deployment for political purposes. The War Powers Resolution has been debated for decades. Supporters have always argued that unauthorized presidential military action violates the Constitution. Now they have a federal court order saying exactly that. In writing, from a judge who evaluated the specific conduct of this specific president, and into Republican political calculations where members who are privately uncomfortable but publicly silent can now point to a federal court ruling, not a Democratic talking point, not an opposition research document, but an official federal court order. As the judicial validation of the constitutional concerns they have been afraid to express on the floor. This matters more than most people realize. Republican members of Congress have been looking for cover. They have been looking for something that is not from the other party, not from the media, not from advocacy groups, that they can cite when they finally decide they have to say something. A federal court order is exactly that thing. It gives them institutional permission to acknowledge what they already know privately. The martial law language in that order makes every one of these political and constitutional arguments more credible, more specifically grounded in official judicial findings, harder to dismiss as partisan overreach, because it came from a judge, an institution whose professional function is to evaluate exactly this kind of constitutional question. And the institution said in writing for the historical record that this looks like an attempt to edge toward martial rule. That sentence is now in the permanent constitutional record of this era. No social media post can delete it. No rally speech can rewrite it. No political spin can make it disappear. It is there, forever, available for every historian, every law student, every citizen who wants to understand what happened during this presidency and what the judicial branch said about it while it was happening. The finding that the president is treating emergency statutes as a license to suspend ordinary constitutional limits is the most significant judicial characterization of a sitting American president's governing theory in the modern era. It is based on a documented three-category pattern rather than a single incident, which makes it broader, more durable, and more constitutionally significant than any ruling on an individual action. The court identified the operating theory underneath the pattern, that emergencies transfer legislative authority to the executive, and found that theory to be constitutionally indefensible regardless of which specific statute or which specific crisis is cited as the mechanism. That theory-level finding addresses the entire governing architecture of the second term, not just one bad executive order. And the emergency injunction that accompanies it signals the court's preliminary assessment that the constitutional challenges are likely to be sustained when the full merits are decided. This is not the end of the legal story. It is the beginning of a judicial confrontation that is going to work its way up through the appellate system while everything else keeps moving. The rejection of the wartime exception theory is the most direct and most legally sweeping part of the entire ruling. It closes the primary escape route the administration has been using to justify its most aggressive emergency authority claims across every domain. The administration has consistently argued that national security emergencies justify extraordinary measures that would otherwise be unconstitutional. The judge found that argument legally insufficient at its foundation. That the Constitution does not suspend itself during crisis, that emergency powers exist within the constitutional framework rather than above it, that specific actions being challenged are not within the scope of legitimate emergency authority, even under the most generous possible interpretation of presidential wartime powers. That holding applies to the Iran war authorization argument. It applies to the domestic deployment planning. It applies to the Emergency Tariff Authority, and it applies to every future emergency declaration that rests on the same underlying theory of suspended constitutional limits. The wartime escape route is closed in this circuit by this ruling. The emergency injunction creates an immediate binary choice: comply and accept constitutional constraint, or defy and trigger a constitutional confrontation more serious than any other legal challenge the administration is currently facing. There is no comfortable middle ground between those two options. Complying means publicly acknowledging that courts can successfully limit emergency authority that the administration has been asserting without limit. Defying means contempt proceedings, escalating sanctions, and the kind of direct judicial executive confrontation that would make every other political and legal problem the administration is currently managing look simple by comparison. The administration's lawyers understand this binary clearly. It is why this specific ruling is generating more internal alarm than any previous court loss, because the tariff ruling was a constitutional loss on a policy question, painful but manageable. The injunction is a direct operational constraint with immediate enforcement mechanisms that cannot be walked around through alternative statutes or creative reinterpretation. The political consequences of martial law language in a federal court order are permanent, specific, and impossible to fully contain through any amount of post-ruling spin. The language exists in an official judicial document that becomes part of the constitutional record of this era. Regardless of what the administration says about it afterward, the characterization strengthens the impeachment articles. It validates the 25th Amendment fitness arguments. It gives war powers resolution supporters a federal court ruling to cite on the Senate floor. It gives Republican members who want distance from the administration a judicial basis for that distance that is not partisan in origin. And it establishes in the permanent constitutional record that a federal court looked at this president's governing approach, evaluated it against the constitutional framework that has governed this country for nearly 250 years, and concluded it looked more like an attempt to edge toward martial rule than like constitutional governance within established limits. That is the sentence history is going to read about this moment. That is the sentence that law students will study in constitutional law classes 20 years from now. That is the sentence that will appear in the documentary footage and the historical retrospectives and the judicial biographies written long after everyone reading this is gone. It is already written, in an official federal court order, where no social media post can reach it, where no rally speech can change it, where no amount of political pressure can make it disappear. A federal judge looked at the President of the United States and told the truth about what he saw. That truth is now part of the permanent record, and nothing will ever remove it. I will see you in the next one.